welcome to the channel. Today in this video we will understand what is consent and what is free consent in contract. So let's get started. The definition of consent is when two or more people agree upon the same thing in the same sense. But free consent means that consent is not caused by coercion, undue influence, fraud, misinterpretation, or mistake. The example is imagine two friends, Aditi and Raj, discussing a business partnership. Aditi agrees to the terms, believing it's a fair deal. However, if Raj had misrepresented the profits to get Aditi's agreement, her consent would not be free and the contract would be voidable. Now let's understand what is standard form of contracts. Standard form of contracts are pre-prepared contracts with fixed terms and conditions, often used by large businesses in repetitive transactions. The other party generally can only accept or reject the contract with little room to negotiate. When you buy a train ticket, you agree to the terms of the railway company, which are usually printed on the ticket. You can either buy the ticket or choose not to, but you can't negotiate the terms, making it a standard form contract. Now let's understand what is void agreement and what is voidable contract. That an agreement not enforceable by law and has no legal effect from the beginning is called void agreement. Enforceable at the option of one party but can be cancelled by them due to issues like fraud, etc., is called voidable contract. The examples are if Ravi sells his house to Sona under threat, Sona's consent is not free. This contract is voidable and she can choose to cancel it. On the other hand, if they make a contract for something illegal like smuggling, this would be void from the start. Now let's understand what is contingent contracts. Contingent contracts depend on the occurrence or non-occurrence of a future uncertain event. For example, suppose Piyush agrees to pay Rahul 5,000 rupees. If Rahul if Rahul's lost pet is found within a week, this is a contingent contract as Rahul's entitlement depends on the condition of finding the pet. Now let's understand what is quasi-contracts. Quasi-contracts arise by law rather than mutual agreement to prevent one party from being unjustly enriched at another's expense. For example, suppose Tara mistakenly pays 1000 rupees into Rahul's bank account. Legally, Rahul is obligated to return this money to Tara, as keeping it would unjustly enrich him without a legitimate contract. Now let's understand what is discharge of contracts. Discharge of contract means ending contractual obligations. Doctrine of frustration applies when unforeseen events make it impossible or radically change the purpose of the contract, leading to its termination. For example, Alex hires a hall for a wedding, but an unexpected flood damages the hall, making it unusable. Due to frustration, the contract with the hall owner can be terminated without liability, as neither party could anticipate this natural event. Now let's understand what are the remedies in the form of compensation. Compensation is awarded to a party that suffers loss due to a breach of contract. Remedies include damages, restitution, specific performance, and injunction. For example, if Priya hires a decorator for her shop but they never show up, she may suffer financial losses and lose customers. Priya can seek compensation to cover her losses from the decorator's failure to perform as agreed. These real life examples illustrate how these legal principles apply in everyday situations. helping you understand the practical impact of each type of contract law provision. I hope you understood the topic, the concept. Thanks for watching.